I'm Emily Lamb. I'm the chair of the authority, and I think we're going to get started. The first item on our agenda is introductions. So I think we'll get started with introductions. I don't know, Bob, are you going to take that?
Yeah, thank you. First, thanks for y'all being here. This is the first meeting of the East Bank Development Authority, and really appreciate everybody being willing to serve. Also want to thank the Titans for offering us the space and the hospitality. We'll start with the East Bank team and Mayor's Office and Law Department, and then ask you all to introduce, although I think you just took care of that in the last 10 minutes, but we'll just do quick introductions. From the East Bank team, we've got Anna Greider from the Planning Department, and Ben York, also from NDOT. Over the last several years, we've had the East Bank team has been really an ad hoc where we borrow employees from different departments to basically work on the East Bank. So Ben and Anna have been with planning and NDOT respectively still to this day, but have been working exclusively on the East Bank for a number of years. They're the core of the East Bank team. I'm Bob Mendez, the Mayor's Office Chief Development Officer. I've been working with Ben and Anna and the East Bank team since Mayor O'Connell came in office last year, about 16, 17 months ago. And I've got with me today Tom Cross from the Law Department, who has been handling legal matters for the East Bank and the large projects on the East Bank for as long as there's been large projects on the East Bank. It's been a while. So maybe we can, wherever you all would like to start, just introductions among yourselves.
Yeah, if you press the right button on the mic, it'll turn it on.
Sure. Thank you. My name is Hal Cato. I'm the CEO of the Community Foundation of Middle Tennessee. Glad to be here.
And I'm Caitlin Dastuk. I'm the COO of the Civic Design Center, and very glad to be here.
I am Nate Carter, the Director of Workforce and Employment.
I'm Scott Tift. I'm a lawyer at a law firm, Barrett, Johnston, Martin, and Garrison.
And I'm Emily Lamb again with the law firm of Winstead.
I'm Jimmy Granberry, CEO of H.G. Hill, and I represent the Lieutenant Governor.
I'm Brian Reams, and I work at Magnolia Investment Partners.
I'm Mona Hodge, and I am partner and architect at Smith G Studio.
Speaker Cameron Sexton.
Thank you. The other introduction that I want to do is just what the East Bank is, and we've got a few slides on that. The East Bank is used generically to mean a lot of different things. Sometimes just very close to the football stadium, other times a much larger area. And when we talk about the East Bank and the East Bank Development Authority talks about the East Bank, it's got a specific meaning that we want to make sure to share with you all before we get too much farther along. This is a map that shows the 550 acres of the geographic area covered by the East Bank Development Authority. It's basically inside the interstates to the river. This is an area that if you were to walk it is the equivalent of going from about Bridgestone Arena to the Parthenon in Centennial Park. It's a pretty big area. I used to say until a couple months ago, there were 0 full-time residents in this area. I think there's an apartment complex that started to get residents, so we're up to about 50, 60 full-time residents on the East Bank. To compare it to other projects of metros, I'm going to compare the size of it to other large projects that you know, the Nashville Yards project, Music City Center, and the Gulch. To start with the Gulch is 60 acres, so about 1/10 of the size of the full East Bank, and it's been under construction since about 1999. So we're a quarter century into 60 acres compared to the 550 acres on the East Bank. Nashville Yards, which we've all seen, there's somewhere around a dozen plus or minus buildings being built in 20 acres, 18 acres in Nashville Yards. They've been working on that since about 2015. And I think anybody who follows the development community would feel that Nashville Yards has gone pretty quickly in building out that 18 acres. Another comparison is Music City Center, which covers almost 15 acres. just a single building. And that from inception of project was about '06, and I think it completed around 2014. So that was about 8 years for that period. By comparison, the East Bank is much larger. And I think y'all will see as we go forward in the months to come, a lot of people use East Bank to mean different things, and they're not necessarily wrong or right, but when we use East Bank, we're talking about the full 550 acres between the interstates and the river. And I think that ends the introductions.
Great. I think we're ready to move on to the next item on the agenda, which is the public comment period pursuant to the Tennessee Open Meetings Act, found at Tennessee Code annotated section 844-101. So is there anybody in the audience who would like to address the board?
If Chair, if you don't mind, I'll read what the ground rules are, and then we can have the
Yes,
gentleman
please.
speak. Under state law, members of the public may offer comments to the board on items on the agenda on which the board will take action. Comments will be limited to 2 minutes per person for a maximum of 10 speakers. The chair will recognize those seeking to comment at the appropriate point on the agenda, which is now.
And Mr. Mendez, should they come to the
Yeah.
chair and speak into the mic? Okay. So as you heard him say, you'll have 2 minutes to speak.
I'm rather familiar with the way
Okay, great. And if you'll just identify yourself by name and address,
It's out of
please.
order when it comes down to it, according to your agenda.
I'm sorry?
I said, regardless of the situation, I'm familiar with the way in which things go.
Right.
He's out of order according to your agenda. He went to number 5 instead of letting number 3 roll. Or you could do your
We're in the
agenda.
public comment period, which is
Right.
item 3.
He just read us up in summary of Open Meetings Act and tried to put the rules down. So either fix your agenda properly in order in which they go, or allow me to speak when I'm supposed to. Anyway, my name is James Johnson. I'm a member of the Homeless Planning Commission, along with the Lived Experience, COC. I'm an equity and diversity member, amongst other things. I'm the Strobel House tenant. The policy reads, under construction, the General Assembly hereby declares it to be a policy of the state that the information of the public policy and decisions is public business and shall not be conducted in secret. Part B, the part shall not be considered or constructed or construed to limit any of the rights and privileges contained in Article 1, subsection 19 of the Constitution of Tennessee, which reads that the printing of the process shall be free to every person to examine the proceedings of legislation or of any branch or office of the government, and now no law shall ever be made to restrain the right thereof. I have an annotation that I won't read. The communication of thoughts and opinions is the one of the invaluable rights of every man and every citizen may able to freely speak, write down, and print on any subject, being responsible for the abuse of liberty, and the prosecution for the publication of papers, especially in business proposals and contracts. That's my annotation and ideals and referendums. Investigating the official conduct of the officers or men in public capacity, the truth thereof may be given, and no secrecy is afforded, annotated by me. As evidence and in an indictment for libel, the jury shall have the right to determine the laws and facts under the direction of the court in other criminal cases. The only comment that I have, and the only question that I do remain to have that wants to be answered by not just me, but many others that are involved, about a $68 million TPAC removal from this East Bank thing, and what does that have on the effect and the affect of the project, and not only the project, but the citizens at large, the taxpayers that are involved. There is one other question that I have as to why there would be a nonprofit MDHA logo on this plan. Imagine the East Bank, when it comes to funding, it has to do with building something that's a public entity owned by a private government, because Metro is the people that own the land, according to the way in which it's written. So there's a few questions that are remain to be seen, because the funding that is for a 501(c) isn't being used as a security or even a right that it is supposed to be there or it is going to be there, short in absence of the actual housing being built. Perfect.
Your time is up, so if you can wrap up your last sentence.
No, that's
Thank
cool.
you.
I'll end right there.
Thank you. Is there anyone else who would like to address the board? Seeing none, I think we're ready to move on to the next item on the agenda, item number 4, which is the summary of the enabling legislation for the East Bank Development Authority.
Good morning. I'm Tom Cross with the Metro Legal Department, and it's my pleasure to be here today. I actually have worked with several of you before, and I met a couple more of you this morning, and we'll be happy to answer questions that you have either about the subjects that I'm talking about or general questions you might have later about what your mission is or your powers and things like that. You might be wondering, like, what are we doing here? Metro doesn't do development on this scale, as you can imagine. You know, Metro is building one-off projects, but when you have a big piece of property like this, and one of Bob's slides showed the scale of the whole East Bank area, Metro would like to have the property to the extent it redevelops, and a lot of it is already undergoing redevelopment in the part that Metro itself owns, as you know, is likely to be redeveloped too. That needs to be done in sort of a coordinated way. And because Metro doesn't have an existing department that does that kind of thing or expertise in that area, we considered what possibilities there might be to assemble that expertise to oversee this, and ultimately landed on the need for an authority to do it with some powers that would be unique among the authorities that are associated with Metro. So this came to be through a private act under the state constitution. If the legislature is going to pass an act that is applicable only to a single county, it has to be opted into by the local legislative body or by referendum. So the state legislature passed a private act applicable to Davidson County only that allows for the creation of this authority. The Metro Council opted into it, and the way this works is they have to opt into it word for word. So both the state legislature and the Metro Council opted into this, the enabling statute that provided for the creation of the East Bank Authority and the membership and the who appoints who and the like. So that's how we wound up here, and I'm sure Bob is going to either today or at some other time is going to talk further about exactly what the vision is for the authority, but it's sort of to oversee this development, and we appreciate the state working with us to get this in place and to help us assemble a group that has expertise that nobody else in Metro does. So we're most of the way to the finish line on this. There's still some other things that are going to need to be done. In particular, one of the things that will be on an agenda in the future is approval of an intergovernmental agreement between the authority and Metro that will provide for the specific powers that the authority can exercise. And one of the things that's possible is for the conveyance of the property, or at least a portion of the property that Metro currently owns in this surrounding the stadium, to the authority for ownership and administration. So, yeah, I've already moved to the next slide here, and I emphasize that first line there, that this all is going to require council approval. These things are not self-executing, but among the things that the authority has the power to do under that private act and the locally approved legislation is to own property and administer it, to plan and install infrastructure, which is a lot of which is going to be necessary here and throughout the East Bank. Provide economic development incentives for affordable housing and public infrastructure. Grant application administration. Some of these things are similar to powers exercised by our Industrial Development Board and some other boards. Typically, if you're going to incentivize construction, installation of infrastructure or other things like that, it can be done through a pilot agreement. Those require collaboration between the board or the authority and the Metro government. But those are pretty expansive powers that you'll be able to exercise, assuming the council grants them to you. You can administer contracts and enter into contracts. You can borrow money. That's typically done, and I'm sure would be done in this case through bond issues. Those two would require council approval. Those presumably would be, the bonds would be funded with revenues that you would have through the leasing of the properties that comprise part of the campus. And then there are lots of different types of authorities that are recognized in state law, and some of them are listed there. This legislation authorizes this board, this authority, to exercise the same set of powers as parking authorities, port authorities, industrial development boards, and housing boards. So these may get explored over time as this campus develops and the board sort of grows into its role. But as envisioned, there are lots of things that this board can do with council approval. Thank you. So again, almost everything that you will do is going to require the council's concurrence. One of the things that was important to the legislature and was worked into the private act is that you cannot condemn property. That's a sensitive subject, as you can imagine. You can't operate businesses that compete with private businesses. It'd be unlikely that you would want to do so, but you can't go into business doing things that others are doing. Some exceptions to that, as you noted from the previous slide, maybe would be to operate parking facilities and the like. And you do not have zoning or land use regulatory powers. Those will continue to be exercised by the council and the Metro Planning Commission.
You want to pause there, see if there's any questions?
Yeah, and I went through that pretty quickly. Again, it's probably going to take some time as the board grows into its role before all of these things get fleshed out.
Does anybody have any questions about the topic that Mr. Cross just addressed? We might have some in the future, but we don't right now. So I think we're ready to move on then to number 5 on the agenda, the summary of the open meeting and public records requirements.
Okay, so this might not strike you as the most exciting subject on this agenda, but I would like to note that these two subjects are really important. The policy of the state law is to make sure that decisions that affect the public get made in public, so that the public has an opportunity to both understand what you're doing and to comment on them, and government decisions need to be made in sunlight. So both the Open Meetings Act and the Open Records Act are aimed at that policy. Generally speaking, your meetings have to be publicly noticed. There's a way to do that through the Metro website. You have to publish your agenda. Again, there's a way to do that through the Metro website. It needs to be done well enough in advance such that people understand what you're proposing to deliberate on and potentially decide at your meetings. There are Metro-specific requirements that we're going to advise that you follow. Generally speaking, we like to see the agendas published at least 5 days in advance, and in any event, not later than the Friday before a meeting on the following week. So what constitutes a meeting? A meeting is really any time when 2 or more of you are together to discuss or deliberate towards a decision. It doesn't mean that you can't go to a Christmas party and talk about things that don't have to do with the business that might come before the board. But to the extent that you're meeting and you're talking about things that are going to be on an agenda for you to deliberate about and to decide later, those things need to be publicly noticed. So obviously that's going to be true even if there's not a quorum there to actually make a decision. So we would advise caution there. This is not meant to be so restrictive that you can't run into somebody on the street corner and say hello, but it does mean that something that's going to be on a future agenda, if you need to avoid talking about it until it's in public. Switch. Yes, please. If there's an emergency, and hopefully this will not affect your business, but it does some other boards and commissions, and who knows, it might affect yours. Sometimes decisions have to be made more quickly than the 5-day notice period and publication agenda will permit. The idea is not to watch the world burst into flames just because you can't comply with that notice requirement. So under an emergency, you can meet more quickly and give the amount of notice that's possible under the circumstances. There are some situations where you can meet with your attorney without the members of the public present, but the restriction under state law is that be when there is pending or threatened litigation. So if the board is involved in litigation or anticipates litigation being filed against it, you can meet with an attorney privately. It could be somebody from our office, or you may hire your own counsel as time goes on here. You can meet with them under those circumstances for the attorneys to explain what the subject of litigation is and strategy and potential risks and advantages of taking particular courses of action. You cannot reach a decision in an executive session, however. If you're going to vote on doing something, it has to be done in a public session following the executive session. This is mercifully rare in Metro's experience, but we have had a couple of occasions where a board or commission did something that violated the Open Meetings Act, typically failing to comply with a notice period or publication of the agenda, like deliberating and reaching a decision about an agenda item or about an item that wasn't on an agenda. And at least in one instance that I can think of, we were sued and placed under the supervision of a court for a period of a year, and the board had to submit written reports to the court to show its continued compliance. You can also subject yourself to attorney's fees to somebody who sues to obtain compliance with the act. So again, just a reminder that these are important. People take them seriously. So that's open meetings at lightning speed. Open records, we get questions about this even from people who are fairly experienced with government. Again, the whole policy of the state is to make sure that people understand how decisions are being made at the government level. Most records that are created by you or for you in the administration of your duties are going to be public records, no matter what format they're kept in. So emails are the category that generates the most. But there are plenty of others. The East Bank team that will ultimately report to you. Their reports and files and plans and contracts are all public records. How does it affect you personally? Well, public business that's done even on private devices is subject to a public records request. So if it's your habit to use your personal email account, like a Gmail account or something like that, if we get a public records request, we're going to ask you to go through your emails that are related to the business that you're doing for the board and provide them to us for review for privilege, then they're likely to be turned over. Conversely, even if it's done on a publicly owned device, like you happen to have a Metro cell phone or use a Metro computer or one provided to you by the East Bank Development Authority, if it's purely private, those are not subject to public records requests. So if you're send an email or a text to your wife and would you please pick something up on the way home, that is not subject to a public records request. But you should assume that most things are, and you shouldn't choose not to do business that's efficient, but you should keep in mind that your records are likely to be requested from time to time, and things that are in your emails having to do with the business of the board are likely to become public. The State Open Records Act is long. It has lots and lots of exceptions for things like personally identifying information, some kinds of personal phone numbers, some kinds of personal addresses. As you can imagine, health information, banking records, and things like that are exempt from disclosure. There are other kinds of things that are subject to privilege. Advice that's given to you by somebody from my department or an attorney you may hire down the road. Those things are protected by privileges and generally not subject to disclosure. If you're asking for legal advice, that's typically not subject to disclosure either. Under state law, we typically have to provide some sort of an initial response to a public records request within 7 days. That doesn't necessarily mean we have to provide the records. If somebody gives us a super voluminous records request that, every email going back 10 years from some people or group of people, that can be thousands and thousands of emails, and we obviously not going to be able to produce them in that 7 days. So the obligation is to advise the requester when we think we can comply. And for one like that, we typically do it in batches. The expectation is not that we or you will drop your ordinary business just to review your records to comply, because pretty soon that's all you would be doing. So we typically agree to produce in batches of, say, 100 that we can get through in a day. So in a week, maybe 500. And I'm telling you this just so you can ease your mind that you're not expected to stop doing whatever your regular work is or even the business of the board simply to comply with a public records request, but it is an additional burden. And that might be it for my slides, and you may well have one more. Let's see. So Metro has a somewhat obscure board that determines retention and destruction schedules for public records is not good business practice either for you or for the business that you're in, or for the government to hold records forever if they're not necessary. But some things we do keep forever. Among them are the board agendas and minutes. So it's possible to tell even years or decades later what actually a board did. Some kinds of contract files are typically kept for 7 years. Employee files for 5 years. This board meets pretty frequently to set retention destruction schedule for other kinds of records that might be new, or when there are changes in state law and the policy needs to be changed, or if something's just not working. But if you're wondering, you don't have to figure all this out for yourself. We're going to advise that you generally follow the guidance that's given by this board. You have questions about either of these? Again, I know we went through that pretty quickly.
I have a question for you, just clarifying. So regarding the public records, I'm talking about the records that we might retain ourselves on personal devices. Does that include, and I don't know, we'll get into this more as we go on, but as we go on, as the agendas are published in advance, if there is any prep work that any of us do on our own, taking notes, writing notes as we go through the packets ahead of time that were provided, or notes that we might take at meetings, or all of those personal notes that we do for our own preparation considered public record?
Your personal notes typically are not.
Okay. Are there any other questions?
I've got a question on the email. Thus far, we've mostly, been trying to figure out how to work together and have had these ad hoc communications. But I think, for me at least, I'd like to designate a specific email that's my email for business here. And also, it also expands into the question of how we should best communicate with each other. And this is my first board and commission. So is there a way within our setup that we designate this is my East Bank Development Authority email for people, or is that more just we need to communicate with each other?
We typically are going to advise that you not email each other directly. The better practice is to email either the board chair for distribution or to a staff member who can do it. And there needs to be a sort of a permanent record of that. If you typically use Gmail or Outlook.com or something like that, you have an email like that, it's best to either have a separate email account on that platform or to designate some portion that you use just for East Bank Development Authority business. Some boards and commissions have Metro email addresses, and that might be better for you too.
Okay, yeah, and that makes sense. I was thinking I would either create or get a Metro, create an email account that's even just emailing the chair or emailing staff or however it was. So just figuring out how we designate, moving forward, please, if you need to contact me, use this email address.
Yeah, Mr. Tift, before I was in the city council, I was a lawyer on a Metro board, and especially with, trying to decide whether to intermingle Metro business with a law firm email account is, raises questions. I think practically speaking, different boards and commissions do different things. As Mr. Cross mentioned, some have set up Metro email addresses, and you guys can already figure out the pros and cons of that. Like, it leaves you another email address to keep track of, which is a pain sometimes, but it does keep things fully separate. Other boards and commissions, everybody does designate their preferred method of being communicated, and then both sides, the Metro side and the board member side, need to be diligent to not drift into using the other one. And so I think that's, I don't know that we need a formal action on that. So maybe we'll commit, me and the East Bank team, to check in with each of you after the meeting and see whether there's some sort of consensus about how y'all would like to approach that. And we can get that figured out.
Great, thank you.
Tom, I had a question relative to the public comment period. Under the state law, isn't there a requirement of notice given by the person requesting to speak?
Different boards and commissions handle it in a different way. Some of them have a sign-up period, just before the meeting. Some of them require that you sign up to speak well in advance of the meeting electronically. You may want to you may want to try one way of doing it and see if it works. If you typically only have one or two people who want to speak or nobody wants to speak, it probably isn't going to be burdensome to you to just allow people to sign up at the meeting or raise their hands at the meeting. If you have a lot of people that want to speak and you need to control it in order to be able to get your business done, you may want to institute a rule that requires people to sign up well in advance.
Thank you.
And is that something that we would discuss and then work into our bylaws, or how would we handle?
You can do it. You can do it through a bylaw.
Okay. Any other questions for Mr. Cross? Then I think we're ready to move on to number 6 on the agenda, discussion of requirements to complete the organization of the East Bank Development Authority.
Thank you, Chair. So had conversations with each of you in advance of the meeting. There's only a few action items for today. And under this agenda item, I think there's 2 action items that we'll get to. One related to bylaws, one related to legal representation. But let me share with you all the thinking from the East Bank team about how to go from the day that we had the state legislature and the Metro Council approve the legislation and the road that we need to travel to become actually operational. And the summary is that from the day in August when the council passed it till hopefully the new fiscal year, July 1, the things that we needed to accomplish were to get a board, get a CEO, assets, employees, and some spending money. The board, we've checked off 1 of 5. We got one of the 5 done. On the CEO, the status is that the law allows the mayor the privilege of appointing the first CEO, and he's engaged in a process right now, and we're hoping to have a CEO in place by the end of February, the end of March. You guys need to get the CEO in place. We're working hard on that. That leaves assets, employees, and spending money. To accomplish those, we're going to have an intergovernmental agreement between the Metropolitan Government of Nashville and Davidson County and the East Bank Development Authority. Intergovernmental agreement, for some of you, maybe the first time you've heard that phrase, it's a fairly common thing. There are intergovernmental agreements between Metro and the Convention Center Authority, Metro and MDHA, I'm sure the Airport Authority, I'm sure the Sports Authority, and others. It's a fairly standard thing, so we can have a formal documenting of how the 2 government bodies will work together. And I'll talk more about the timing for that in a second, but before we get to having y'all consider and approve an intergovernmental agreement for the council to consider also, we need basic structural things in place. We need a set of bylaws for y'all to operate off of. And when it comes to that intergovernmental agreement, we recommend that the authority have separate counsel than the law department. And so those 2 things need to happen. And let me switch slides here. I think all of you know what bylaws accomplish. We are thinking on our side, but it's up to y'all, that the first set of bylaws should be pretty basic. For example, often bylaws would say there's going to be a finance committee or an executive committee or some other committee. Well, right now, there's not a lot of business for y'all to do, and there's not finances really until an intergovernmental agreement is approved. So we'd recommend that there be a relatively basic set of bylaws to start, and then calendar either 6 months, 9 months, a year from now to reconsider whether committees need to be created or the bylaws need to be amended. But clearly that's up to you all. So let me pause there. I do think y'all should take action in figuring out how you're going to go from no bylaws to having bylaws. We recommend that the chair could work with legal, but it's really up to y'all about how to do that.
Does anybody have any comments on that? So they recommended that I work with legal to come up with the first set of bylaws, and then, as he said, very basic, and then we can look at them again in 6 months or 9 months or a year. I'm happy to do that if the board sees fit, but open to any other suggestions as well.
I'll make a motion to go that direction.
Second.
All in favor?
Aye.
Aye.
Aye. So that motion carries. So I will work with Metro Legal on some bylaws, and maybe have them by the next meeting. We'll work on that.
All right, great. Thank
Yeah, I was
you.
going to say, as a follow-up, it would proposing to the group, would it make sense that our goal is, in an ideal world, to be able to review and approve next meeting, if possible? It may not be possible timing-wise, but that's the first step that we need, really.
From our perspective, and we'll talk more about the intergovernmental agreement in a few minutes, but or right now, in order to have employees and money, it would make sense to get the intergovernmental agreement approved by y'all and the Metro Council before we get into our Metro budget cycle, which is in May and June. And so it's not urgent, like it's not the end of the world if you guys don't approve bylaws, but I do think there's in order to get the entity up and going, it would be helpful if the intergovernmental agreement is approved by April, which would mean getting bylaws sooner rather than later.
And I would think, and I'll see if Mr. Cross has anything to say on this, but I would think certainly for some basic bylaws that it sounds like we're going to do for the beginning, it would not be a problem to get them worked on and reviewed in order to make a recommendation, bring them to the board before the next meeting. So I know that Metro Legal has full plates, so I'm going to let Mr. Cross weigh in on the timing of that.
Yeah, we can definitely do that. We've got a draft going.
Okay. So we can we can plan on having that for your consideration and approval for the next meeting.
And let me add, there's a lot of, most Metro boards and commissions have a board package in advance of the meeting. For this first meeting, there really wasn't anything to put in the board package. I would anticipate that for something like this, whatever the recommended bylaws are, that we would have them in a board package available the week before the meeting, so y'all would have time to consider it before the meeting. Similarly, probably goes without saying, but I'll say it, when we do that with other boards and commissions, that board package also gets posted publicly for the world to see what you all be considering. So we plan on installing that for the next meeting when there's actually materials for y'all to consider.
Bob, would that include contact information as well of whatever our preferred contact is?
Yes, and Mr. Granberry, we created the sort of standard issue Metro website for the authority that currently, I'm glad you asked that, currently has the email addresses that I've been using to communicate with y'all. And so it is important if y'all want a different email address, or if you decide to have Metro email addresses, we should definitely get that squared away by the time of the next meeting. And again, me and the team will work with you guys individually afterwards to figure out what that method's going to be.
And our main point of contact would be you for the time being?
Yes. As soon as we get the CEO appointed, then that person would be the main point of contact. But for now, I'm standing in as that.
Lucky guy.
Happily so.
Anything else for the bylaws specifically?
All right, so y'all took care of that. Next is the legal representation. Again, for coming up with a basic set of bylaws, law department has no conflict with that. When we get to this intergovernmental agreement, there's two parties to the contract, Metro, East Bank Development Authority. Law department will represent Metro. We think y'all should have separate counsel for that. And you guys need to figure out how to do that. Our recommendation, again, like the bylaws, is to because of public meetings rules, it'd be hard. We can't have 3 of y'all, 4 of y'all, subgroup of y'all shopping lawyers offline without calling public meetings. A pretty typical way for us to deal with it would be for the body to designate the chair to do the legwork to get recommendations for the next meeting for y'all to consider then. And it's not binding, just recommendations. That's the suggestion.
I'd like to make a motion to that effect.
I'll second.
All in favor?
Aye.
Aye.
All right.
Motion carries.
Unanimous. Appreciate that. So that takes care of 2 of the items. And then a little bit more about the intergovernmental agreement. So we have we've worked on the Metro side for a draft, or it's barely a draft. It's sort of an outline, and basically the things once we have board and CEO, then it's that assets, employees, and how to get money to pay employees. And I'll give you guys just the thinking about where we're at on this. I'll work backwards. For the money part, 10 years from now, when there's multiple high rises here paying rent, we contemplate that the rent would come into the East Bank Development Authority, and it would pay for its expenses. It would keep reasonable reserves, not unreasonable reserves, and then remit whatever the balance is to the metropolitan government. So it's easy. It's really, frankly, easy to figure out how the finances are going to work for operating expenses 10 years from now. Right now, there is no rent. So we anticipate proposing to the authority that Metro would cover the operating expenses until such time that rent is adequate to cover it. And so that's where we're imagining the operating money coming from. That's going to be our suggestion. As far as assets, Metro has a 99-year development agreement with the Fallon Company for 30 acres. The thing is 450 pages long. And we contemplate that Metro would assign its rights under the development agreement to the authority to operate, to act as landlord for the land for the 99-year period. That agreement passed by the council a year ago was drafted in anticipation of having the authority. And so there's nothing needs to be done to alter or amend the documents. We just would simply need to assign it amongst our Metro and the authority, and then the authority would stand in that place. We're sure we want to propose that. That would cover assets. A thing that is still open for further discussion is whether the authority owns the Metro-owned land or does a long-term lease for Metro. Practically, they're essentially the same, and we're not sure which one we're going to propose yet, but that's a thing that would be in the intergovernmental agreement. If we're transferring land ownership, it would convey title of the land to the authority. We've got an airport authority that owns land. We've got a sports authority that owns land. So it wouldn't be unusual. If it's a long-term lease, it would be a 99-year lease to match up with the length of the development agreement that we have with Fallon. So that would get the authority 2 substantial assets: an ownership in the some or all of the Metro-owned land on the East Bank, and all the rights of the property owner in the 99-year development agreement. It's obviously a lot of details there, but that's basically what it would do to get assets. So that covers assets and spending money. And then the third thing is employees. Just 10 years ago, we set up the Convention Center Authority for the first time, and we're going to propose using the standing up of the Convention Center Authority as a model. In that situation, we took Metro employees that were full-time with the Convention Center Authority and moved them over to be employees of the Convention Center Authority in a way that preserved their status as with Metro pension in particular. So there wasn't a disincentive for employees to move over. Here, we're going to propose the same thing, that core group of Metro employees who are paid by Metro now, members of Metro departments, get moved over to be employees of the authority in a way that is fair for them about some of their retirement benefits. And that's the basic. We're going to want the intergovernmental agreement to have some rules of the road, some understanding about what sorts of things the authority does versus what sorts of things Metro departments like NDOT is going to continue to do. We don't think the authority wants to be in charge of manhole covers and certain things in roads that NDOT's in charge of. So it's not going to be just a full divesting of all Metro responsibilities in the East Bank to the authority. And we need to draft that in a way that'll last for 99 years, but give some rules of the road about how the entity and Metro are going to interact. So that's the thumbnail sketch about what we think is going to be in it. If we had to, I think on the Metro side, we could propose a draft to the authority next month for sure. We think it really makes sense for y'all to have counsel to give you advice about that agreement in enough time to hopefully make a decision we would like by April. So again, we can get ahead of our budget process, especially the part where if Metro is going to pick up the operating expenses until such time that there's rent, we need it in the budget this year, and not. So that's the basics of what we anticipate for the intergovernmental agreement. This information, there's no action required today. It's for information, but happy to answer any questions y'all have about that.
So just to make sure I'm clear on the timing, the idea would be for us as the authority to hire outside counsel with a recommendation potentially at the next month's meeting. Hire that outside counsel, and then from there, that outside counsel would work with Metro Legal on the intergovernmental agreement for us to review and address potentially in the March or April meeting, so that Metro has it in time for the budget. Is that right?
That's exactly right,
Okay.
and more succinct than the way I put it. I would love to think that we could knock it out by the March meeting, but it seems prudent to. It'll be the first time y'all saw it. Like, it wouldn't surprise me if you had a bunch of questions at the March meeting that you wanted explored before April. But yes, March or April.
And presumably, if we hire outside counsel, that attorney will come to the meeting to advise us
Right.
in the meetings as
Yeah.
well. Okay.
Hopefully over these next several.
Sure.
By the time the intergovernmental agreement is being deliberated on and voted on, it would be my goal that it is our goal, the mayor's goal, that it's neither me nor Mr. Cross that are giving y'all information, that it's a new CEO and the outside lawyer. So we don't have, we're all in the Metro family, but it would be better if when we get to that spot in April or March, if that's when the voting is, if it's somebody other than Mr. Cross and I talking to y'all about it.
That was going to be my question. What is the CEO's role in the intergovernmental agreement? Is there one, or is it this group that leads the charge on that?
Both. I think if we use other substantial authorities in Metro as a guide, if it's the sports authority or the airport authority, the ultimate decision lies with the authority. But I wouldn't say deference to the CEO, but the CEO is in charge of understanding it at a very line by line way that you all hopefully will be able to rely upon favorably. But I guess it would be expected that you guys would ask whatever questions you want to, especially since it'll be a new relationship with the CEO. Y'all have to ask what you want to make sure you're comfortable.
My question is really about timing. If the intergovernmental agreement's really establishing our operating funds and assets, and we want to get council on board, how are we paying our council and negotiating with the CEO on benefits and salaries in a reasonable way?
Yeah, so the CEO, I'll address first, and then maybe hand it to Mr. Cross for lawyer. For the CEO, because we do have a chicken and the egg of there's not money today, but we would like to hire somebody today. We have worked with the finance department to find a way in Metro's current operating budget. If we hire a CEO today, we'll figure out how to cover the salary right off the bat, one way or another, and then we'll be transparent about what that is. And I'm assuming the intergovernmental agreement will clean up any loose ends about debits and credits on that. And legal counsel, I would anticipate that whoever that is might have to bet a couple months' work that we're going to figure out how to get them paid once the intergovernmental agreement's taken care of. I'm guessing somebody will take that risk. Good question.
Thank you.
Anything else? All right. So that gets us through item 6. So I think moving on to item 7, we need to set the next meeting date.
Yes, and on that, so we picked the third Wednesday in the month because that's a day that doesn't have any other major Metro boards meeting. That matters mostly so we can get the video feed live. I think that the community prefers to get a live feed. This is being broadcast live today as opposed to being recorded. And so y'all can pick whatever frequency of meetings you want, whatever you want. If you want to stick with the third Wednesday of the month, we can do that. If you guys want something else, it's really if we come up with something else, I'm going to ask for a half-minute sidebar with the TV broadcast folks to figure out whether it's one of their no-fly zones.
As we consider this, do you have any recommendations for the frequency of meetings in terms of what business is coming our way?
I would expect it should settle in at monthly.
Okay. So the third, once a month, the third Wednesday, does this work for everybody? You look like it doesn't work for you.
Wednesday is actually the only day that doesn't work for me.
Okay.
Typically.
Okay.
But any other day is good.
You may need to take if Wednesday doesn't work for him, if you want to take a sidebar to see if there are any other days and times that work, or it sounds like, are there any other days besides Wednesday that doesn't work for Mr. Cato? Are there any other days that don't work for anybody?
Well, I'm guessing, I know somebody up here has got every day slammed through April. Mr. Cato, do you want to propose what day week works best for you?
Let me ask you this. So you're here today. Is it possible just for the next meeting for us, could you do next month on Wednesday, and then that would give us time to work with the Metro Nashville
for at least the
network?
next one or two, but then
Sure, but not indefinitely. But could you make it work for the next meeting? Okay, so that would be the third Wednesday in February, the 19th. Does the same time, 10 o'clock? Does that work for everybody?
I would suggest maybe 9 o'clock.
9 o'clock. Great.
You don't have to break the day up.
Early bird catches the worm.
6 o'clock. If
I like it. I get up at 4 o'clock. Yeah. 9 o'clock work for everybody?
Yes. 9 o'clock's good.
Do we need to make a motion for that?
I think so.
Okay.
Motion 9 o'clock Wednesday, the 19th, and then once we get our bylaws, we'll establish a
Sure.
more consistent pattern.
Is there a second? All in favor? Aye.
Aye.
Okay, so February 19th at 9 a.m., same location. Mr. Mendez, will we have this room?
Yes, let's say that for the next meeting, subject to double checking with our host. We'll have to figure out where it is in long-term among other things, this building won't be here in a couple of years. But this was convenient for our first one because both our broadcast folks and the Titans know the drill for how to get it set up. And since the East Bank team was sort of it's first time for us, we relied on something that was easy.
Okay. Okay, so we'll be back February 19th at 9 a.m. and then we can maybe by the next meeting have some idea of what might work for the folks who are broadcasting it, and then come up with a date that works, or a regularly scheduled meeting date that works for everybody's calendar.
Great, thank you.
So I think that's it. I think
Could I just one thing to throw in there, and this is not coming just from me. Bob and I have talked. I know he talked to many of y'all. I think it makes sense these first few months. There's some big picture items that we're not well informed on yet that we may want to be preparing to have, each one of them addressed sort of seriatim through several meetings. I don't know that we need to vote on that or anything like that, but Bob and I talked about sort of anticipating for the first few weeks a business section of the meeting and a presentation section, and the biggest item out of the gate, which would be February, if people agree that this made sense, would be having a good presentation on the East Vision, complicated detailed plan that planning worked on for several years with input that's going to guide a lot of what we're thinking about. So I just wanted to raise that and mention that. A few of the other big things would be understanding the Fallon Agreement, starting to get a handle on infrastructure challenges and opportunities. Those are three that we had discussed, which makes sense to me. So I don't know that we need to vote on it, but I can at least speak for myself. I think it'd be great to hear a presentation on the East Bank Vision Plan in February, in addition to our business.
I think that's great, and I think that, as you said, there is a lot that we don't know because we have not been in the weeds for the past however many years. So I think that's a great place to start. I would also anticipate that we would need to do this going forward, maybe have a section for each meeting. But certainly, if you'll have any particular subjects besides what you've mentioned, otherwise I think we can defer to Metro and staff on what, as the business comes our way, what makes sense for us to be trained on when.
Bob, is there any way we can get, not the 895-page Fallon Agreement you referenced, but, just a Cliff Notes version of that, a Cliff Notes version of the infrastructure issues, and then the planning document? I know that's a lot of plans, but it would be nice to have that just to kind of prep in advance of the meeting and kind of.
Yeah, thanks for that. Somebody, I can't remember who, suggested that we come up with a board resources page, and we can start doing that and get that information disseminated to you all. Metro has a lot of resources about the East Bank in a couple different places. Some that are not so helpful for you. Back in the last council term, there was a lot of materials gathered at the Metro Council website. But I think we should, I think that's a good idea that we could start pulling some of those materials to a resources page for y'all. And I guess I'd offer, if there's something in particular y'all want to see, let me know. And we can target to within a week or so. Does that sound good? To get the makings of this posted and send you all a link so you can look at it and see the materials. The Fallon deal, I'll figure out some sort of summary. But I think Mr. Tift is right. When I think about what the intergovernmental agreement, I think talking about the vision plan, I think we should do that. And I think you guys do need to hear more about the Fallon deal because Metro would be assigning it to the authority. So we'll get going on that. And then I guess we'll plan for the next two meetings, at least maybe setting aside a 2-hour block. And if we don't use all of it, that's fine. And we'll plan on the first half for business, and then the other half for getting up to speed on things. And if we don't need the full 2 hours, that's fine. If that works for everybody.
One question, looking at the slide in front of us, the authority member responsibilities, required training. Is there going to be annual required training for us, or is that something that will be covered in these the trainings?
I don't think it's typically annual, but there is some training that's required.
Okay. And that would be
It has a
separate
longer
from
life
these
than that.
meetings?
Yes.
Okay.
We'll get that pulled together. There's been different laws passed at different times about, I don't know exactly what the trainings are. I know when I was board member, I didn't necessarily, I always loved a learning opportunity, but it takes a little bit of time.
Sure.
So we'll get you all more details about what exactly the requirement is. I think that's it.
Anything else from y'all? Anything else from any of the board members? Okay. Sure.
The inner parent in me, before we adjourned, came out when he said that he couldn't make it on a Wednesday. I know a lot of us up there might have kids, but when the summertime hits, school is out, we want to schedule family vacations and things of that nature. So I think we need to think about if we was doing the third Wednesday of every month, like we might have to prioritize trying to figure out a way to just schedule it for that meeting, the next meeting that we have. Because I don't know what everybody else got going on, but I know when my kids out of school, summer get here, they want to go. So
I think for the next at least one meeting, maybe two, we might stick with Wednesday, and then after that, we'll come up with a set time. And I think that we can, and that would be scheduled presumably a year in advance. Typically, meetings or the meeting dates are published at the beginning of the year, so we can work vacations around that. When summer comes, I want to get out, so my children are out of my house. So I hear you.
yes, ma'am.
Okay. If there's no other questions or comments, I think the meeting's adjourned.
All right.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.